Arkansas has one of the least regulated breaking lease frameworks in the entire country, consistent with the state's overall minimalist approach to landlord-tenant law. As we've discussed in our other Arkansas videos, the state is one of only a few that has not adopted a comprehensive residential landlord and tenant act, and the landlord-tenant relationship is governed by a combination of Arkansas Code Title 18, Chapter 17, Common Law Principles, and the lease agreement. If you're dealing with a broken lease in Arkansas, the lease contract is your most important document because the statutory framework provides minimal guidance. Let's start with the landlord's duty to mitigate damages. Arkansas recognizes the landlord's duty to mitigate through common law principles. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit vacant and hold the departing tenant liable for the full remaining rent without making any effort to find a replacement. The landlord must take reasonable steps, advertising, showing, and accepting qualified applicants. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced. Because Arkansas's mitigation duty is common law rather than statutory, the standard of what constitutes reasonable efforts is less precisely defined than in states with detailed statutes. Courts evaluate reasonableness based on the circumstances, the local market, property condition, and the landlord's typical practices. The lack of specific statutory guidance makes documentation of your re-rental efforts particularly important. Your records are the evidence that you acted reasonably. Early termination clauses are generally enforceable in Arkansas. The state does not cap early termination fees or restrict how leases handle early departure. Arkansas courts enforce contractual provisions between private parties, and a clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. Arkansas's legal culture gives significant deference to negotiated contract terms. Because Arkansas lacks a comprehensive landlord-tenant act, the lease agreement fills the gap that statutes fill in other states. This makes the lease, including the early termination clause, critically important. A well-drafted lease with clear breaking lease provisions is your primary compliance tool in Arkansas. Military members have the right to break a lease under the SCRA. Arkansas has a moderate military population. Little Rock Air Force Base near Jacksonville generates military rental demand in the Jacksonville and Cabot areas. Ebbing Air National Guard Base in Fort Smith and various reserve and guard units generate some additional demand. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Arkansas does not have a specific state statute providing enhanced lease-breaking protections for victims of domestic violence. Arkansas does have the Domestic Abuse Act, Title 9, Chapter 15, which provides protective orders. However, the Act does not include a specific provision allowing early lease termination based on domestic violence status. Domestic violence victims in Arkansas who need to break a lease must rely on general contract principles, negotiate with the landlord, or seek assistance through advocacy organizations like the Arkansas Coalition Against Domestic Violence. This is a significant gap in Arkansas's framework, and one that landlords can address voluntarily by including a domestic violence termination clause in their leases. Tenants in Arkansas may break a lease if the landlord fails to maintain habitable conditions, though the path is less defined than in states with comprehensive habitability statutes. Arkansas courts have recognized a basic implied warranty of habitability in residential leases, but the scope and procedures are less developed than in most states. If the landlord fails to address serious health and safety issues after receiving proper written notice, the tenant may claim constructive eviction as grounds for termination. To establish constructive eviction, the tenant must show that the conditions were serious enough to substantially interfere with habitation, that the landlord was notified and given a reasonable opportunity to repair, and that the tenant actually vacated within a reasonable time. The tenant should provide written notice identifying the specific deficiencies, document the conditions with photographs and written records, and allow a reasonable time for the landlord to respond. If the landlord fails to act, the tenant can terminate, but the process should be thoroughly documented because Arkansas courts evaluate constructive eviction claims on the facts. Arkansas has a unique criminal eviction provision under Arkansas Code Section 18-16-101 and following, which allows tenants who fail to vacate after proper notice to be charged with a criminal misdemeanor. This provision applies to the eviction context rather than the breaking lease context, but it reflects the state's strong property rights orientation and the broad discretion given to landlords. Arkansas does not have a detailed statutory framework for handling abandonment. When a tenant abandons the property, leaves without notice, removes belongings, and stops paying rent, the landlord must determine abandonment based on the circumstances. The landlord should document evidence: unpaid rent, absence from the property, removal of belongings, disconnected utilities, failure to respond to contact attempts, before entering and re-renting. The departing tenant remains liable for damages subject to the mitigation duty. From a practical standpoint, Arkansas has a diverse rental market with dramatically different dynamics between Northwest Arkansas and the rest of the state. Northwest Arkansas, Fayetteville, Springdale, Rogers, Bentonville, has the strongest market in the state. The economy driven by Walmart, Tyson Foods, J.B. Hunt, and the University of Arkansas creates deep demand. When a tenant breaks a lease in Northwest Arkansas, the landlord can typically re-rent within 2 to 4 weeks, and often faster in desirable areas. The departing tenant's financial exposure is usually limited. The NWA applicant pool is diverse. Corporate relocators, university students, and poultry processing workers all break leases for different reasons and in different circumstances. Corporate relocators may break because of a job transfer and are often willing to pay an early termination fee without dispute. Students may break at semester end. Processing workers may relocate when employment circumstances change. Having a clear early termination clause that applies to all these situations streamlines the process. Little Rock has a moderate market. Re-rental varies by neighborhood. The Heights, Hillcrest, and Riverdale have moderate to strong demand. More affordable parts of the metro take longer. Little Rock AFB near Jacksonville generates military rental demand, and SCRA terminations are routine. Fort Smith has a moderate affordable market. Jonesboro, home to Arkansas State, has a student-influenced market. Hot Springs has a moderate market driven by tourism and healthcare. Pine Bluff has one of the most challenging markets in the state: population decline and high poverty-constrained demand. Re-rental can take months. Landlords in Pine Bluff should set realistic expectations and structure leases with shorter terms, rather than expecting to enforce long-term lease break damages. The Delta region of eastern Arkansas has the softest markets in the state. Extended vacancy is common even without a broken lease, and pursuing the full remaining rent from a departing tenant in a market where the unit might sit empty for months regardless is both impractical and legally vulnerable given the mitigation duty. One best practice for Arkansas landlords, because the state has essentially no statutory framework for breaking leases. Your lease agreement is your most important tool. Include a detailed early termination clause that specifies the notice period, fee amount, how the security deposit will be handled, the condition the unit must be returned in, and the process for both planned terminations and abandonment. In the absence of statutory guidance, your lease fills every gap. Another best practice: document your mitigation efforts meticulously. Arkansas's common law mitigation duty means courts evaluate reasonableness on the facts, and your documentation is the evidence. Keep records of listing dates, advertising channels, inquiry counts, showings, and when you accepted a replacement tenant. Include costs for cleaning, repairs, and advertising. A third best practice: consider voluntarily including a domestic violence early termination clause in your lease. Arkansas doesn't require it, but allowing termination with 30 days' notice and a copy of a protection order protects vulnerable tenants and reduces the risk of a tenant fleeing without notice. In a state where the statutory framework provides minimal protection for domestic violence victims, a voluntary lease clause fills an important gap. Arkansas does not have a comprehensive statutory framework for security deposit returns comparable to most states. The rules are governed primarily by the lease terms and common law. Best practice is to include clear deposit language in your lease, specifying the return timeline, the process for claiming deductions, and the itemization requirements. Most Arkansas landlords follow a 30 to 60-day return timeline. These practices apply whether the departure is a normal move-out or a broken lease. For the complete guide to Arkansas breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.